just to make sure we understand where we are on the timeline of the Hatfield and McCoy feud so far. New Year's night, 1888, the cabin of Randolph McCoy was shot up and burned down. We have the confirmed deaths of 2 children, Calvin and Allaphare McCoy. We have Sheriff Frank Phillips crossing the West Virginia border from Kentucky to arrest 9 men for the murders and several others for resisting arrest. There was a question as to the legality of this action. The governors of the state of Kentucky and West Virginia have now sent troops to their borders to stop other raids and trying to calm tensions. The Tug River Valley is in an uproar. This lawsuit will affect how bounty hunters will operate in the hunting of criminals when they cross over to other states for many years to come. On February 9, 1888, the governor of West Virginia presented to the District Court of the United States stating that on September 1887, the governor of the state of Kentucky requested the arrest of Pliant Mahon for the alleged charge of murder, and that he had fled to and was still at large in the state of West Virginia to avoid justice. He further petitioned that during the month of December 1887 or January 1888, the said Pliant Mahon, while a resident and residing in the state of West Virginia, was in violation of her laws, the Constitution, and the laws of the United States. Also that Mahon was arrested without warrant or legal process by a body of armed men from Kentucky, and by force and against his will was taken out of the state. At the same time as these events, another petition was presented to the court by one John A. Shepherd, stating that his case was also like that of Pliant Mahon's and that the governor's facts were true. Subsequently, the name of Pliant Mahon was substituted for that of John A. Shepherd, and the proceedings on the petition were conducted in his name. The court then placed an order for the jailer, Abner Justice of Pike County, Kentucky, to bring the person of Pliant Mahon to the District Court of the United States in Louisville, Kentucky, on the 20th of that month, and there to abide until the decision was made in the case. The Pike County jailer's response was that Mahon was being held in the Pike County jail under the obedience of the 3 arrest warrants issued by the clerk of the criminal court of the county. Under these warrants, Mahon was being held for the crime of willful murder that had been alleged to have been committed in the county, a crime for which the court had full jurisdiction. The jailer was proceeding to the city of Louisville to produce the body of Mahon before the United States District Court, where he was met on the way by a United States Marshal of the District of Kentucky. The United States Marshal had then taken custody of Mahon by the order of the District of Kentucky. Abner Justice further replied that the 3 indictments against Mahon and the others for the willful murder of the McCoy children were found by the grand jury of Pike County, Kentucky, stating that the grand jury had jurisdiction over the case at the time. Believing these statements by the grand jury to be authentic and true, it was certified by the governor of Kentucky, and the said governor appointed Frank Phillips as the agent of the state to receive and bring to the state Mr. Mahon as provided by law in such cases. On or about January 12, 1888, Frank Phillips and others with force of arms did violently seize upon and capture Mahon, and did bring him against his will to face charges in the state of Kentucky. In his statement, Justice went on to further reply that no arrest warrant was issued against Mahon by the governor of the state of West Virginia in compliance with said requisition. That on January 30th, 1888, replied to the governor of the state of Kentucky that after investigation of the facts, and being fully satisfied in the case, that he could not find guilt in Mahon for the crime in which he was being charged. Then on February 1st, 1888, the governor of the state of West Virginia demanded from the governor of the state of Kentucky the release of Mahon from Pike County Jail, and his safe return to the state of West Virginia. The governor of the state of Kentucky denied this request, stating that it was not in the duties and powers of the acting governor of West Virginia to determine the matter, but a case for the courts, and further held Mahon in custody pending trial. On March 3, 1888, the courts denied the motion for the release of Mahon, and the marshal was then ordered to return Mahon to the custody of the jailer, Abner Justice, awaiting further court actions. The Supreme Court became involved in the feud in 1888. The case is listed under Mahon v. Justice, 127 U.S. 700, 1888. The state of West Virginia argued that Pliant Mahon should be released from confinement, set free, and returned in safety to the state of West Virginia, as Mahon had been illegally arrested, seized, and confined in the common jail of Pike County, and deprived of his liberty by the state of Kentucky. The state of Kentucky argued that the prisoner in custody should remain so until the trial, and that the state was under no obligation to release them to the state of West Virginia or any other entity, regardless as to how they were arrested and retained. Mahon's attorney argued that the governor of the state of West Virginia was considering an application from the governor of the state of Kentucky as a fugitive from justice when he was forcibly abducted by Phillips. Mahon's attorneys also made the argument that he was then seized by the Kentucky state authorities under legal process and was not entitled to be discharged from the custody under a writ of habeas corpus from the Circuit Court of the United States. The Supreme Court of the United States of America ruled 7-2 in favor of Kentucky. The Supreme Court issued no finding or opinion on the question of legality of the arrest of the group of men. However, they did agree with the state of Kentucky that at that time no law existed which prohibited the trial of the men for the murder to continue. The trial would carry on regardless of how they were arrested and brought into the state. The two dissenting judges, Mr. Justice Harlan and Mr. Justice Bradley, both agreed that the writ of habeas corpus was properly issued and the prisoner Mahon should have been discharged and released from custody, that he was being held against his will, and this was contrary to the Constitution and the laws of the United States. Both judges felt that he was kidnapped and was carried into the state of Kentucky by force, which is a plain violation of the Constitution of the United States, and for him to continue to remain in the state of Kentucky was a violation of his constitutional rights. While it is true that Mahon was charged with a crime in the state of Kentucky, the Constitution provides for a peaceful remedy for procuring the surrender of the persons charged with a crime for fleeing to another state. Such laws and treaties were put into place between the states for just such events. It was felt by these two dissenting judges that the states could take justice into their own hands and demand of each other reparations for illegal invasions of their states, if this ruling was also allowed to stand. That also that the parties who were injured legally or otherwise could resort to reprisals or other measures that they might deem necessary in order to obtain justice. It is interesting that Ansi Hatfield was not among those that were arrested and tried. Neither Kentucky or West Virginia sought for his arrest in any of the events that took place, even though his location was well known and a bounty of $500 was placed upon his person at one point during the feud. Ansi Hatfield was never charged with the murders of the three McCoy brothers, or for the shooting of the two young McCoy children, or the beatings, kidnappings, or other things that were done, even though he was also known to use the courts to his advantage when it came to matters between the two clans in the feud. When the main trial was over, Hatfield was not on the run after that point in history. Many have pointed out that it may have been Hatfield's political connections that kept him from being arrested. However, his brother Wall had similar connections and thus was arrested, tried, and convicted and sent to prison. The stage is now set. The players are at their marks. The curtain begins to open for all to see. In the next video, the trial of Ellison Mounts and the rest of the Hatfields will take place, and the shocking outcome from that trial. This is the end of part 5. We hope that you have enjoyed the series of the feud so far. Thank you for watching.